Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hello, I'm Angela Princewill, and today I am going to talk to you about this very focused topic of retroactive child support. A fulsome child support conversation can be heard on episode 11 in our fundamental series. So for those who don't know what retroactive child support is, it is essentially child support that's owing for any period of time before you bring an application for child support. So in very practical terms, if say you have a child support obligation arising out of a separation that happened in January, say 2020, and now we're in June 2021, well, the support that should have been paid for that period of time, it may be that no child support at all was paid or that child support was underpaid. Well, all of that amount owing for that period is retroactive child support. And, if the application is brought in June 2020, the courts will order retroactive child support to account for that period of time where the obligation existed. Obviously, if the recipient is successful. So I'm going to be using the words recipient and payor. Payor just refers to the person that's going to be paying child support, and the recipient is clearly the person that's receiving the child support payments. So if you've ever dealt with a retroactive child support issue in the past, or even if you're doing your research, you would probably run into two Supreme Court of Canada decisions, and those are DBS and Mitchell. They're cases that really laid out the factors that the courts look at when deciding retroactive child support issues. And really, what are the issues we're looking at? Essentially, it's usually one party not, the payor, not agreeing that there's that obligation to be paid, or even if they agree that there's the obligation, they probably don't have the ability to pay the retroactive child support. And obviously from the recipient, they want to make sure that they receive the child support that they were entitled to. And so that's generally the conflict that we're looking at there. And so in resolving these conflicts with the Supreme Court of Canada just kind of gave these guidelines. Essentially, they look at four factors. So we're looking at delay. Was there a reasonable excuse? And it used to be, was there a reasonable excuse for why child support was not sought earlier by the recipient? Was there blameworthy conduct on the part of the payor parent? What are the circumstances of the child and the hardship to the payor from having to pay this lump sum child support as a result of a retroactive award? So what the courts have done recently is look at these factors and apply them to, I guess, life as it is today. So when DBS, for example, was decided, that was in 2006. At the time, the guidelines did not exist. And now, fast forward to 2021, so many years after, there is the child support guidelines. It's pretty much mainstream. Child support is now really looked at as more of a mathematical exercise. You're supposed to know, there's the expectation as a payor that you know that you have a child support obligation, and the amounts that you need to pay are already set out in the guidelines. The way to determine your income is pretty much set out. I mean, obviously there's exceptions, but for the most part, the idea is that majority of the population know that there is child support obligation, can fairly easily determine what the child support amount should be. And so, these factors have to be interpreted in light of that. So for example, there was a recent decision that dealt with this issue, and looking at the factors in that sort of light, the court said, well, with delay, they're saying the delay by a recipient in bringing a child support application shouldn't really, it's not such a high threshold because it doesn't really prejudice the payor parent. Again, because the court is saying as a payor, you ought to know that you have a child support obligation and and how it should be calculated. So given that you have this information advantage, and because, there might be other reasons why a recipient might not be able to bring a child support application, that there's really no prejudice to you as the payor. So the recipient, for example, may be unable to bring that application for financial reasons, or because they were victims of abuse and things like that. So the courts are saying, well, the fact that the recipient did not bring this application in a timely manner doesn't really matter that much to you, because you did know that this obligation existed. When we also looked at blameworthy conduct, there was almost a subjective element to it, right? And, the payor didn't think they were doing something wrong, then they weren't considered to be engaging in blameworthy conduct. And now what the courts have done is they've said, even failure just to disclose an increase in your income is blameworthy conduct. And by that, I mean, if your child support obligation, or if your child support, say at the time of separation, was based on a lower income, if that income increases, you're expected to know that you should increase your child support as well accordingly. So the fact that you didn't know and you just did not disclose your income, that in of itself could be blameworthy conduct, right? Because again, you have the information advantage. In looking at the circumstances right, of the child, what the courts are saying is there is no requirement to prove need on the part of the children. And the child support is the right of the child, and children are entitled to expect and receive child support from both their parents. So, it's irrelevant if there is a step parent, for example, that has significant means and the children are provided for. The court is saying, no, there's no legal obligation on that person. As a parent, the children have a right to expect to receive child support from you. On the issue of hardship, the courts say, well, we recognize that with every, immediate lump sum cash payment that's awarded, there is bound to be financial, difficulty and financial hardship. But in as much as there may be hardship, the courts are saying without more, it's not undue or unfair. And without more means a lot more, because there's been cases where the payor is in significant amount of debt and had a significant debt payment to service, and that was still not sufficient for the courts. So, sometimes payors think, well, if they accrue a large enough lump sum retroactive child support, that maybe the courts would reduce it because of the hardship of paying that lump sum and things like that. But don't bank on that. That may not happen. The courts is saying, well, we recognize that there may be a hardship to you, but it's not undue and it's not unfair, because as the payor, you have in fact benefited from failing to fulfill your full child support obligation. So that's it on, retroactive child support. I do recognize that there's situations where people make alternative arrangements for child support. If you want to avoid any confusion down the road, or, double paying, if you feel like, okay, I've been asked to maybe make these purchases in lieu of child support and things like that, do try to articulate it. If the courts recognize that, of course, there's times where other reasonable arrangements can be made for the support of a child, but it's important that you articulate those so that it's clear and there's not this conflict of whether, those clothing that you bought and things like that are in fact were supposed to be in place of child support, because on a general note, it's really not. So just be careful if you're making alternative arrangements around child support, because you may find yourself in a situation where you might still be awarded or may still be asked to pay retroactive child support. So that's it for today. Again, refer to our previous podcast on child support if you want a fuller picture. As a recipient, remember that, the fact that you haven't asked for child support, or you've been asking and haven't even received child support for any period of time, doesn't mean that it's all gone. Just ask the courts for retroactive child support and make sure that you kind of, position your claim based on these factors that I've spoken about. One more thing I need to mention is this issue of when the courts will, how far would they go back? So generally, the courts will go back 3 years from the date of either effective notice or formal notice. If an application is being brought today, for example, then today is the date of effective. Today's the date of formal notice. So you do know, if you receive my application today, you know that I've given you notice of that. So the courts would go back 3 years from today, and at the minimum, if appropriate under the circumstances, clearly, and calculate the child support. But there's situations where a person has been, maybe sending text messages and emails and maybe started asking for child support to either be increased or even paid at all. And this may date back even a couple of years back. And at that point, you had effective notice, right? So the courts can even go back 3 years from that time and make that award for retroactive child support. So that's it for today. Until next time, bye for now.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.